If you die tomorrow, a judge you have never met will take legal control of everything you own. Your family will not be able to access your bank accounts. They will not be able to sell your home. They will not be able to pay your bills or settle your debts without explicit court permission. That process is called probate, and it will cost your heirs between 3 and 8% of the total value of your estate paid to attorneys, appraisers, and the court before your family sees a single dollar. On a $400,000 estate, that is between $12,000 and $32,000 taken off the top. And it will take between 9 months and 2 years before the process is finished. Most people have never heard a clear explanation of what probate actually is, what it actually costs, and most importantly, which assets go through it and which ones do not. Because the biggest misconception in estate planning is that having a will protects your family from probate. It does not. A will is not a way around probate. A will is the document that tells the probate court what to do with your assets after the court takes control. Here is what we are covering today. First, what probate actually is the legal process, who controls it, and what it means for your family. Second, what goes through probate and what does not. This distinction alone can determine whether your family waits 2 weeks or 2 years. Third, the real cost of probate, attorney fees, court fees, appraisal costs, and what states charge as a percentage of your estate. Fourth, the 4 most effective strategies for avoiding probate completely. Fifth, the specific situations where probate cannot be avoided regardless of your planning. And sixth, exactly what you need to do in the next 30 days to protect your estate from the court system. I am Marcus Webb, and this is Benefits Decoded. I focus exclusively on estate planning and retirement wealth protection. The most consistent thing I see in my work is that families who go through probate are almost never families who planned for it. They are families who assumed that having a will was enough and found out too late that it was not. To understand exactly what is at stake, consider what happened to the family of a man named Daniel. Daniel was 63 years old. He was a retired electrical contractor in Tennessee. He had worked for 38 years, owned his home outright, had a savings account with $90,000, a brokerage account worth $210,000, and a small commercial property he rented to a local business that generated $2,000 a month in income. His total estate was worth approximately $900,000. Daniel had a will. His will clearly stated that everything went equally to his 2 adult children, Sandra and Michael. He died unexpectedly from a heart attack in December. Sandra and Michael assumed they would be dealing with paperwork for a few weeks. What they actually dealt with was 22 months of probate court. Here is what happened. Daniel's will had to be filed with the probate court in his county. The court appointed a personal representative, in this case Sandra, to manage the estate. Before a single asset could be transferred, Sandra had to publish a legal notice in the local newspaper for 3 consecutive weeks, giving any creditors the opportunity to file claims against the estate. Then she had to wait 4 months for the creditor window to close. Then she had to pay an appraiser to value the commercial property. Then she had to file an inventory of every asset with the court. Then she had to get court approval before she could sell the commercial property, which took an additional 6 months because the buyer's financing fell through and she had to go back to court for approval to accept a new offer. By the time probate closed, Sandra and Michael had paid $11,000 in attorney fees, $3,200 in court costs, $4,500 in appraiser fees, and had lost the commercial property tenant who moved out during the uncertainty, resulting in 14 months of missed rental income at $2,000 per month. For a total of $28,000 in lost revenue, their $900,000 estate cost them $46,700 and 22 months of their lives before they inherited a single dollar, and all of it was completely preventable. Chapter 1, what probate is and why it exists. Probate is the legal process by which a court supervises the transfer of assets from a deceased person to their heirs. The word comes from the Latin probatum, to prove. The probate court's job is to prove that a will is valid, identify and inventory the deceased person's assets, notify creditors and pay valid debts, resolve any disputes among heirs, and then distribute the remaining assets according to the will, or, if there is no will, according to the state's intestacy laws. The reason probate exists is that the government cannot simply take your word for who owns what after someone dies. Without a legal process, family members could dispute ownership, creditors could be defrauded, and assets could disappear. Probate is the mechanism that creates order in what can otherwise be a chaotic transition of wealth. The problem is that probate was designed for a different era when most people owned only 1 or 2 assets. when family structures were simple, and when estates were settled locally. Today, people own multiple accounts at multiple institutions, real property in multiple counties or states, complex investment portfolios, and digital assets. The probate process has not kept pace with modern financial complexity. What was designed as a 3 to 6 month process routinely takes 12 to 24 months. The probate process begins when someone, typically a family member, files the deceased person's will with the probate court in the county where they lived. If there is no will, the court still supervises the distribution of assets, but it applies the state's default inheritance rules, called intestacy laws. In either case, the court appoints a personal representative called an executor, if named in a will, or an administrator if there is no will to manage the estate. That personal representative then has legal authority to act on behalf of the estate. But that authority comes with obligations: inventorying assets, notifying creditors, paying debts and taxes, filing court accountings, and eventually requesting final distribution. Every significant step requires court approval. Every court appearance involves fees. Chapter 2. What goes through probate and what does not? This is the most misunderstood aspect of estate planning, and it is the reason that a will alone is insufficient to protect your family from probate. Assets that go through probate are assets owned solely in your name at the time of your death, with no other mechanism to transfer them automatically. This includes bank accounts in your name alone with no payable on death designation. It includes real estate titled in your name alone. It includes investment accounts with no transfer on death designation. It includes personal property vehicles, jewelry, artwork, collectibles worth more than your state's small estate threshold. Assets that do not go through probate bypass the court entirely, regardless of what your will says. We discussed this in our episode on beneficiary designations. These non-probate assets include any account with a named beneficiary retirement accounts, life insurance, annuities. They include accounts with a payable on death designation. They include accounts with a transfer on death designation. They include assets held in a revocable living trust. And they include assets held in joint tenancy with right of survivorship. The critical point is this: your will has absolutely no legal power over non-probate assets. If your IRA names your brother as beneficiary, your will cannot override that and give the IRA to your spouse. We covered this in detail in the beneficiary designations episode. The same principle applies in reverse. If your brokerage account has a transfer on death designation naming your children, that account transfers directly to them on your death, completely bypassing probate and bypassing your will. This means that whether your estate goes through probate depends almost entirely on how your assets are titled and whether they have designated beneficiaries or transfer mechanisms in place. Two people with identical wills and identical estate values can have completely different probate outcomes depending on how their assets are structured. The most common probate trap is real estate. A home titled solely in one person's name almost always goes through probate when that person dies. It does not matter if the will says the house goes to the spouse. The house must go through the court process before the title can be transferred. In most states, that takes between 6 months and 18 months. During that time, the surviving spouse may be living in a house they do not legally control, unable to refinance, unable to sell, and unable to make significant decisions about the property without court approval. Chapter 3. What probate actually costs. The cost of probate is one of the most consistently underestimated expenses in family financial planning. People think of it as paperwork. It is not paperwork. It is a court-supervised legal process that involves attorneys, appraisers, accountants, and court clerks, all of whom charge fees. Attorney fees are the largest component. In most states, attorney fees are either billed at an hourly rate or calculated as a percentage of the gross estate. California and Florida, for example, have statutory attorney fee schedules that set the allowed fee as a percentage of estate value. 4% on the first $100,000, 3% on the next $100,000, 2% on the next $800,000, and so on. On a $750,000 estate in California, the statutory attorney fee for both the attorney and the personal representative together is approximately $34,000. That is before any extraordinary fees for contested matters, real estate transactions, or tax issues. Court filing fees vary by state and county, but typically run between $300 and $1,500 for the initial filing, with additional fees for each subsequent court appearance. Appraisal fees are required for any real property, business interests, valuable personal property, or assets that are not publicly traded. A real estate appraisal typically costs $500 to $1,000. A business appraisal can cost $5,000 to $15,000 or more. Publication fees are required in most states. You must publish a notice to creditors in a local newspaper for a set number of weeks. This costs $100 to $500. Bond fees may be required in many states for the personal representative to post a surety bond to protect the estate against mismanagement. Bond premiums are typically 0.5% to 1% of the estate value per year. Accounting fees are often necessary to prepare estate tax returns, income tax returns for the estate, and final accountings for the court. When you add all of these costs together, the total expense of probate for an average estate runs between 3 and 8% of the gross estate value. On a $500,000 estate, that is between $15,000 and $40,000. On a $1 million estate, that is between $30,000 and $80,000. These are not hypothetical worst-case numbers. They are the realistic range for a normal, uncontested probate proceeding in most states. And then there is the time cost. During the probate period, which averages 12 to 18 months nationally and can extend to 3 years or more, in complex or contested cases, your family cannot fully access or control the assets in the estate. If your family depends on the income from a rental property you own, that income stream may be disrupted while the property sits in probate. If your heirs need to sell your home quickly, they cannot do so until probate is complete. If estate assets are invested in volatile markets, they may lose significant value during a prolonged probate period while the family waits for court approval to move them. There is also the emotional cost, which cannot be quantified but should not be underestimated. Grieving families should not be navigating court systems. They should not be publishing legal notices in newspapers. They should not be hiring attorneys to appear before a judge to get permission to transfer assets that were always intended for them. Every month of probate is another month that a family cannot fully close the chapter on their loss and move forward. Chapter 4. 4 strategies to avoid probate completely. Strategy 1. The Revocable Living Trust. A revocable living trust is the most comprehensive and flexible tool for avoiding probate. When you create a trust and transfer your assets into it during your lifetime, those assets are no longer technically owned by you, they are owned by the trust. When you die, the trust does not die. Your successor trustee takes over, distributes the assets according to your instructions, and the entire process happens outside of any court. No probate, no delays, no public record. We covered how a revocable living trust works in depth in episode 2 of this series. The key point for our discussion here is that a trust only avoids probate for assets that have been transferred into it. A trust that exists on paper but has not been funded, meaning assets have not been retitled in the trust's name, provides no probate protection. This is one of the most common and costly estate planning mistakes we see. A trust was created, the attorney charged for the drafting, and the assets were never moved into it. When the person dies, everything goes through probate as if the trust did not exist. Strategy 2. Beneficiary and transfer designations. For accounts that allow a beneficiary designation or a transfer on death designation, retirement accounts, life insurance, annuities, bank accounts, brokerage accounts, keeping these designations current is the simplest and cheapest way to keep those assets out of probate. A properly designated account transfers directly to the named beneficiary on presentation of a death certificate. No court, no attorney, no delay. We covered this in full in episode 4. Strategy 3, joint tenancy with right of survivorship. When 2 people own property as joint tenants with right of survivorship, the surviving owner automatically takes full ownership when the other dies. No probate required. This is commonly used between spouses for real estate, bank accounts, and investment accounts. However, joint tenancy has significant limitations that people overlook. It only solves probate for the first death. When the surviving owner later dies, the property will still go through probate unless they have other planning in place. Joint tenancy also creates gift tax exposure, creditor exposure for the joint tenant, and loss of control. You cannot remove a joint tenant once added without their consent. For these reasons, joint tenancy is a useful tool in some circumstances, but should not be relied on as a primary estate planning strategy. Strategy 4. The Ladybird Deed. In states that allow it, including Florida, Texas, Michigan, Vermont, and West Virginia, a Ladybird Deed, formerly called an Enhanced Life Estate Deed, allows a homeowner to transfer their home to a named beneficiary at death without going through probate, while retaining full control of the property during their lifetime. The owner can sell it, mortgage it, or change the beneficiary at any time without the beneficiary's consent. This is a powerful, low-cost tool for keeping a primary residence out of probate in states where it is available. Chapter 5. When probate cannot be avoided. There are situations where some degree of probate is unavoidable, and it is important to understand these exceptions so your planning accounts for them. Solely owned real property in a state that does not allow transfer on death deeds and is not held in a trust will go through probate. If you own real estate in multiple states, you may face ancillary probate, a separate probate proceeding in each state where real property is located, in addition to the primary probate in your home state. A person who owns a primary residence in Ohio and a vacation cabin in Colorado will face probate in both states unless both properties are titled in a trust or have other transfer mechanisms in place. When there is no valid will and no non-probate assets, the estate goes through intestate succession probate under the court's default rules, which may not reflect your actual wishes. This is particularly problematic for unmarried partners, blended families, and estranged relatives. When an estate is insolvent, when debts exceed assets, probate is often unavoidable to establish the priority of creditor claims and conduct an orderly liquidation. And when a will is contested, when heirs dispute its validity, the mental capacity of the deceased, or the circumstances of its signing probate litigation can extend the process for years and consume a substantial portion of the estate in legal fees. Chapter 6. What to do in the next 30 days. Step 1. Take inventory of how your assets are titled. For every significant asset you own, your home, bank accounts, investment accounts, retirement accounts, life insurance, vehicles, any business interests, determine whether the asset is in your name alone, jointly held, in a trust, or has a beneficiary or transfer designation. This is the foundation of your probate exposure assessment. Step 2. Identify your probate risk. Any asset titled solely in your name with no transfer mechanism is a probate asset. Add up the value of those assets. That number represents the portion of your estate that will go through probate if you die today without changing anything. Step 3. Consult with an estate planning attorney about a revocable living trust if your probate exposed assets exceed your state's small estate threshold. Every state has a simplified probate process for small estates, typically under $100,000 to $150,000 in probate assets. If your exposed assets are above that threshold, a trust can eliminate virtually all of that exposure at a one-time cost that is almost always less than the probate fees you would otherwise pay. Step 4. Ensure all accounts that allow a beneficiary or transfer on death designation have current, accurate designations. We covered the audit process in episode 4. If you have not done this, do it now. Step 5. If you own real estate in a state that allows transfer on death deeds or ladybird deeds, discuss with your attorney whether adding that designation to your home title makes sense for your situation. Here is the bottom line. Probate is not a catastrophe. It is a manageable legal process, but it is a process that costs money, takes time, creates public record of your family's finances, and forces grieving people to navigate a court system at the worst possible moment. Every dollar that goes to the court and to attorneys is a dollar that does not go to your family. Every month your family spends waiting for probate to close is a month they spend under financial and emotional stress that could have been prevented. Daniel's family lost $46,000 and 22 months to a process that a revocable living trust would have eliminated entirely. The trust would have cost approximately $2,000 to set up. The math is not complicated. If you are watching this and you do not have a plan to keep your estate out of probate, you have work to do. Start with step 1. Know how your assets are titled. Everything else flows from there. If this episode gave you clarity, please share it with someone who needs it. A parent who assumes their will is enough. A sibling who has never heard the word probate. A friend who is putting off estate planning because it feels complicated. I am Marcus Webb. Thank you for watching Benefits Decoded. Every episode of this series is designed to give you the complete picture, not just what to do, but why it matters and what it costs when you do not. Take care of your family. I will see you in the next one.